I'm suing Honey right now. My name is Tom Kherkher. Okay, that was an obscure John Goblikon reference. Go follow him, best creator on this platform. I'm suing Honey. I'm suing Honey. There's a lot of misconceptions on the internet about the Honey lawsuit, so I figured I would debunk them. Specifically 5 things, starting with the very first thing. Legal eagle. Play the clip.
So on behalf of creators everywhere, I have filed a class action lawsuit to stop it. It's time to put my money where my mouth is. So I, along with some other great attorneys, filed suit on behalf of all creators and businesses who have been harmed by Honey PayPal.
So what Devin doesn't tell you is the great lawyers he's working with, it's me. It's my law firm, EKSM. In my opinion, one of the best class action firms in the country. Thanks for the love, Devin. So misconception number 1, and this one is a little bit playful, but the other ones are actually real, is the eagle is not flying solo. In fact, I have an outtake from his video.
Creators are saying that Honey is a scam. They believe that Honey steals from creators. So on behalf of creators everywhere, I have filed a class action lawsuit with Attorney Tom, the greatest and tallest lawyer on the planet, to stop it.
So there you go. Moving on to the second misconception is who we're representing. Play the clip.
Now here's the thing with the complaints. The complaint focuses and is on behalf of creators. We have this whole other category, right, of consumers who are using Honey that are not represented in this particular complaint. So there needs to be a separate complaint just for them. Obviously, it's a little bit more of a stretch. There's more of an argument of, well, what's the harm that people are suffering in that, well, you still got a discount allegedly, but maybe it wasn't quite as much as you should have received. So the allegation is that what Honey is doing is it's talking out of its mouth on one side and saying, hey, come use our platform, use our extension. We're going to help you find the best discounts on the internet, hands down. But then on the flip side, allegedly, Honey is going and actually doing deals with merchants and saying, hey, well, if you want us to give a certain percentage, it's not going to be your actual best coupon. Maybe we can also get some kind of kickback. And so they're doing deals with the different companies that they're working with. So there's the consumer scam side of this discussion and the creator scam side of the discussion / actual lawsuit.
That was a clip by fellow legal creator, top music attorney. She very correctly points out that she believes, and I believe as well, that consumers might have a claim against Honey as well, whether it's a deceptive trade practice, false advertising, probably some other things as well. But just to reiterate, the lawsuit that we filed is not on behalf of consumers. It's on behalf of creators and affiliate marketers. So creators, not consumers yet. Now, you might ask yourself, why? Why aren't we representing consumers? Play the third clip.
Wasn't there a ruling not too long ago that said, like, no one reads the terms of service, so you really can't put in legally binding shit like that? I vaguely recall that being a actual court ruling. This agreement contains 1. An arbitration provision, 2. A waiver of rights to bring a class action lawsuit against us, and 3. A release by you of claims for damage against us that may arise out of your use of the service to the greatest extent permitted by applicable law. By using the service, you agree to these provisions. Their lawyers are good. They've got the Sharingan out. How could they have seen the potential class action coming? They stopped us before we even started. I wonder how far by applicable law goes. There's no way that's going to actually protect them. You can't just say, like, you can't sue us and then do blatantly illegal shit. That's not how that works.
Unfortunately, Charlie, you're probably wrong here. The sad state of current American jurisprudence is that arbitration agreements and class action waivers are oftentimes upheld. Now, for internet arbitration agreements, you're going to look at whether the arbitration agreement was some implicit consent through a browse wrap agreement or explicit consent through a click wrap agreement, meaning did the consumer actually click on it or was it just buried in the terms and conditions? Regardless, here consumers, as a part of signing up for Honey, did agree to an arbitration agreement and a class action waiver, meaning we probably couldn't bring a class action on behalf of consumers. Although I say probably, I reserve the right to change my mind based on any additional research that comes up, more so than we've already done, because I believe forced arbitration agreements are incredibly predatory and have massive negative implications on society as a whole. If you want to go down that rabbit hole, look up the Federal Arbitration Act, the FAA. It was initially passed and is supposed to be a very minor statute and has just cascaded into an anti-consumer hellhole that I think needs to be repealed or replaced with a better law. So, creators, not consumers. Why? Consumers likely have ARB and class action waiver. Now, that doesn't mean they don't have a claim. It just means that if there is a claim, they have to go to an individualized arbitration. That is something that could potentially transpire. There could be a mass arbitration against Honey. I just don't know that yet. We are focusing on the class action representing creators who did not have contracts with Honey, thus no class action waiver, no arbitration agreement. We're representing creators and affiliate marketers against Honey in a class action, not consumers. Fourth clip, play it.
Guys, I was scammed, and unfortunately, I also scammed you. Wow, we have so much in common. Both of us scammed, partially by me, partially by bad people, and we are suing them. That's right, I, Lord Nuxenor himself, am suing Honey with the help of Legal. That's right, we're all coming together. Class action lawsuit. He might not know I'm involved, but that's okay, because I am a victim of this entire situation as well.
This is perhaps the most common misconception. Nuxenor is technically wrong right now. We just filed this class action lawsuit less than a week ago. We filed in the Northern District of California because that is where PayPal is located, the San Jose division, because PayPal is located in San Jose. When you file a class action lawsuit, it does not mean you have a class. It does not mean you represent a class yet. We are going to have to ask the court to grant class certification. Now, the court will have discretion to grant that or not grant that, and if they do grant it, who is within the class? There will be a class definition. So what I'm trying to tell you is don't count your chickens before they hatch. Side tangent, I see a lot of comments online saying this is a slam dunk case, easy case. No, it's not. It's not. I've never had an easy case in my career. And I'm sure PayPal will hire extremely competent, extremely professional, extremely proficient lawyers to advocate on their behalf. So all that's to say is, Nuxenor, you are not part of this lawsuit now. Only the named plaintiffs are. We are seeking class certification, but there's nothing ever guaranteed in the law. So if you're an affected creator and you want to get involved, you should affirmatively reach out to us or another lawyer or whoever and get involved in the case that way. Because you never know, maybe class certification isn't granted. I hope I'm wrong. I hope I'm wrong. I'm just trying to be technically accurate for the sake of legalities, right? I'm a lawyer. So, class cert, short for certification, uncertain for now. The last thing I want to talk about is this comment. Show it on the screen. Should be right here. Couple things. Every client that signs up with my law firm, every client, almost every client, disclaimer. I tell them the average lawsuit takes between 2 and 5 years. The average lawsuit, 2 to 5 years. This will not happen quickly, and you're not going to get paid $1 bazillion, right? It's about setting realistic expectations. We, of course, want to recover as much for the creator economy as possible. I've been involved in a lot of lawsuits that get a lot of hype at the beginning, and then people forget about them. The lawyers, we have to work on this thing for the next 2 to 5 years, on average. Maybe longer, maybe shorter. I hope shorter, but there it is. 2 to 5 years. Okay? Those are the biggest misconceptions that I'm seeing online about the case. It could very well involve a consumer angle at some point, and if it does, I'm sure you will know, because Devin, not me, because this video is going to get 2,000 likes or 2,000 views. 2,000 likes would be a lot. There it is. There it is. Go subscribe to Necro Goblicon. All right, bye.